to the flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Recording announcement, Sunshine Law permits audio and video recording during the meeting. Roll call.
Mr. Feely.
Here.
I'm present. Mr. Prescott.
Here.
Purpose of the public hearing is advertised to review and consider for adoption a proposed zoning ordinance and map. I turn the hearing over to Michael Kearney, the hearing officer.
Thanks, Dave. If anyone that plans to testify or ask questions, if you want to stand and get sworn in right now. Anyone from the audience?
I have questions?
Yeah, if you want to comment, yeah. We'll just swear everyone in right now. That's easier.
Anyone that's going to speak, please raise your right hands, please. Solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
I do. Thank you.
Okay. As everyone's aware, but just for the record, we'll do just a quick kind of procedural background, factual background to how we got to this hearing date and time. As you're aware, stemming back in middle part of 2016, there was numerous meetings, workshops involved related to the possibility of implementing zoning in Donegal Township. Following consent motions, the matter was sent to the Donegal Township Planning Commission beginning early part of 2017. According to the Planning Commission, they held public meetings related to the zoning matter in January, February, March, April, and again in May of 2017 related to the matter. The Board of Supervisors also held a hearing on this matter dated, I believe it's dated August 3rd, 2017. I will incorporate, as a reference, the hearing transcript and exhibits as this hearing. So the August 3rd, 2017 hearing transcript and exhibits will be incorporated herein as this Exhibit 1, hearing Exhibit 1. Following another motion filed in court, it was consented to and sent back to the Donegal Township Planning Commission for further review. On October 2nd, 2017, the Planning Commission held a public meeting and voted to approve and recommend the current draft and zoning map to the Board of Supervisors. The minutes related to that October 2nd meeting will be entered in here as Exhibit 2. On or about October 12th, 2017, in accordance with the municipality's planning code regulations, the proposed ordinance was sent to the Washington County Planning Commission. That email will be entered in the correspondence there as Exhibit 3. By letter dated October 12th, the township received comments and review letter from the Washington County Planning Commission. That document will be entered into as Exhibit 4. Following those items, the Board of Supervisors set the hearing date for tonight's date and time. Those were advertised in the Washington County Observer Reporter on November 7th and November 14th in accordance with the notice provisions required under the MPC. We'll enter those exhibits, proof of advertisement, as Exhibit 5. Which brings us to the current draft of the zoning ordinance and the zoning map, referred to as the May 25th zoning ordinance and the June 15th, 2017 zoning map. We'll enter those as Exhibits 6 and 7, respectively. Okay, we'll first address the zoning ordinance itself, now that we've dealt with the procedurally. Under the MPC, in the second-class township code, a Board of Supervisors or municipality are able to enact zoning to regulate certain uses in a township. Under the MPC, there's a set way of going about doing that. That is the procedure that we just discussed herein. Now what is in front of the board is to consider this proposal of this draft ordinance and the regulations contained therein. We'll go over those throughout here. Under the MPC, one of the requirements of the zoning ordinance is to outline the general purpose and character of the zoning ordinance to reflect the township's comprehensive plan and the nature of the township. I will direct the board and the public to page 1 of the zoning ordinance, specifically section 103, general purpose. This sets forth the purpose of the zoning ordinance. We won't touch on all of it, but it's to promote and protect the public health, safety, general welfare, coordinated, practical community development, density, population, etc. It's also to maintain the stability of agricultural, residential, commercial, industrial, open space areas within the development moving forward of Donegal Township. That's kind of the idea behind what the zoning ordinance is proposed to do. I will then move you on to section 202, the zoning map, and also section 203, which talk about zoning district purposes and uses. Under this zoning ordinance, there are 3 zoning districts. One being the agricultural, the second being the village district, and the third being the mixed use areas. If you look at the map, the zoning map there, the vast majority of the township, 85% of the township is zoned agricultural. The idea behind that in the meetings and as stated in the ordinance is to keep the rural character of the township. It's a rural agricultural based township with a few pockets, areas along the Route 40 and also around the highway corridor that has some commercial viability. That's reflected in the zoning map here in the districts therein. As I said, there's also the village district, which is a little bit of an area outside on the border of Canonsburg Borough, and also the area that used to be, well, still is.
Like that
West,
Claysville.
what did I say?
Canonsburg.
Yeah, Claysville.
Yeah.
Claysville Borough, and then also West Alexander, which used to be a borough but has now been incorporated, but the village aspect and the characteristics of the village district still maintained, and they're showing up in the proposed zoning map. I'll then move on to page 5 and 6, which outline various land uses in the township. And this proposed ordinance has 60 of them. And depending on what a proposed use an individual would want to do, it could be a permitted use, it could be a conditional use, it can be a use by special exception. Those are all different types of uses that a township, a municipality are allowed to implement as part of zoning. These are all types of uses that are permitted within a township. If you look at, just for example, if you look at number 39, a multi-family dwelling townhouse, depending on what district the use that's being proposed is going to operate in is going to determine the various characteristics and the various regulations one would have to abide by, meet, satisfy in order to have that use be implemented in that zoning district. So, in this case, if you wanted to do the townhouse in an ag district or a mixed use district, it would be a conditional use. There'd be criteria that you have to follow related to conditional uses. If it was in the village district, it would be a permitted use. Still subject to regulations that are contained in herein, but a different process. And so that's kind of set forth in all these, the table of uses here on page 5 and 6. The next section that we move on to talk about the dimensional criteria. Again, looking at these, it's designed to keep the characteristic of the township or to define the characteristic of the township moving forward, how you want it to remain or how you want it to go moving forward, how it's going to look moving forward. For example, once again, just using the townhome, if you're in a village district and you look at the setbacks for front yard setbacks for whether that's parking or the principal structure, if you look at it, it's not applicable for parking, and it's 0 setback in the village district. Whereas if you wanted to do that same use, but it was in a mixed use or an agricultural use zone district, you would have different setbacks, different requirements. And again, the idea behind that is that you want to create less density in certain areas as reflected in the agricultural with a minimum lot area, as opposed to what a village or a mixed use might have. You're not necessarily as concerned with the density aspects of it, which makes sense. A village obviously much closer. So that's what the dimensional criteria set forth here in on page number 7 here. Moving forward, as we talked about, there are different types of uses. One of those being a conditional use. If an individual, using the townhouse as an example, were to have to apply for a conditional use, beginning on Article 3, page 8, sets forth the general criteria for the evaluation of conditional uses. That sets forth what an application has to have in it, and the different criteria that are going to apply to any conditional use, not just a townhouse. Doesn't matter what zoning district, but anything that is a conditional use are going to have to rely and going to have to be able to show that they can meet the standards set forth beginning in section 301 of this ordinance. We'll continue on to page 10. On section 302, there are additional provisions for oil and gas development and related uses. One of the concerns in the township throughout the meetings that I'm aware of, the ones I attended, I got involved in January of 2017. One of the concerns that was brought up from the residents and the members of the Planning Commission was that they wanted to better regulate, and from the board, you wanted to better regulate oil and gas, but you did not want to be too restrictive on it and hinder development. The main concern that we heard was that the township residents wanted to be aware when development was happening and wanted to have a chance to have a say on how that development occurred. By making a majority of the oil and gas development as a conditional use, back in, if you look at the table of uses, most of those are conditional uses, that helps to set that goal. And then starting on section 302, any of those oil and gas development related uses set forth specific provisions that the oil and gas industry would have to meet as part of the conditional use process. Different setbacks, work hours, a PPC plan, different types of financial security that they'd have to put in place, permits, those things. Those are all set forth here within the zoning ordinance. Moving forward onto section 303, begins at the bottom of page 11 and then continues on. The specific uses that were labeled on that table of uses, the 60 different uses, a majority of those are conditional uses. If you go back and you look at that, there's a lot of C's in there. Starting on section 303, the various uses are labeled there that have specific criteria. So again, an individual that has a conditional use that they want to come through, they have to meet the general criteria of a conditional use plus any specific criteria listed for that use. And so if you go through here, starting on page 11, and you move on, you see that there's provisions for a care facility, mobile home parks, et cetera, et cetera. You'll notice that some of these areas are quite lengthy, and other ones are shorter in nature. A lot of that reflects the discussions that were had at the various planning commission meetings. That does not mean that this board has to accept all those. That does not mean this board cannot amend all those, amend those further, add to them, delete from them. But what is here, specifically mobile home parks, I believe another item that was discussed at great length were junkyards, adult establishments was another item of great length. And again, like we talked about, a lot of the oil and gas regulations have specific criteria there as well. So that just kind of gives you an idea. If you wanted to do one of those uses, you have to meet the general criteria. You have to first see where it's permitted, what that is, the zoning district you want to have it in. If you can meet those setbacks, those general criteria of a conditional use, and then the specific criteria as set forth in these various uses. Jumping forward, I will note that at a court proceeding this morning, there was some testimony raised concerning some of the conditions, some of the items that were contained in here. One of the items dealt with compressor stations and processing plants. So I'll just direct your attention to starting on page 32, section 303.12. It's entitled Compressor Stations and Processing Plants. One of the issues was that previously discussed, matters might not have been, in their opinion, fully explained to the board or to the planning commission or to the public at large. And so I just want to point to the board so that you are aware that on page 33, if you look at the very top, one of the issues that was amended was the minimum lot size for a processing plant. It reads shall be 80 acres. So I want to point your direction to that. And also one of the other items I believe, and the public can correct me if I'm wrong, is also under subsection C, number 1, talks about a setback for compressor stations and processing plants to be at least 400 feet from an occupied structure. Those two provisions, based on conversations we had with the industry, and similar provisions we have in other townships, were put in, and so they were reduced. I think it used to be 100 acres for the minimum lot size for a processing plant, and I believe the setback was 500 feet previously on setback C1. So that's something to consider for the board, and I believe the draft has that highlighted as one of the items that was changed previously, but just, you know, so you're aware, that's something to consider. It was amended down. And just wanted to bring your attention to that item.
Michael,
Yes.
is it appropriate to, while you're on it, I had a question on that, address it while you're on it, rather than go through everything?
I think it's probably better just to go through, and then we can open it up. We'll open up to the board, and then once the board has questions, comments, then we'll open up to the
I
public.
just had a comment or question on that specifically that you're talking about.
Okay. Well, you'll have an opportunity to have it addressed.
All right, thank you.
Yep. So again, the various uses found throughout section 3 deal with that in the different provisions. And as I stated, some are longer, some are shorter. Another item that I want to direct your attention to would be, I believe it's on page 38, 37. Yeah, page 37 is the medical marijuana uses. Starting on page 37, you'll see at 303.19, there's a medical marijuana dispensary, and then moving forward, there's also a 303.20, a medical marijuana grower processor. Those uses, throughout the process of the planning commission working on this, that use was approved. It previously was not a possible use in the state of Pennsylvania, at least not a legal use. The state changed the law and created those uses. You know, those are now uses, they're state permitted, but those uses were created. We then implemented those into the township zoning ordinance. The idea behind the zoning ordinance is we have 60 uses, as we said, but you're not gonna be able to identify everything. You're not gonna be able to amend the ordinance every time some type of use comes up. The idea behind it is that you are constantly working on this. The planning commission's reviewing it. You know, there are provisions, and we'll get to that this can be amended from time to time down the road. If this, you know, if you ultimately choose to adopt this or a form of this, it's still a living, breathing document that can be amended. However, you can't always be ahead of the curve. Things come in. And so I'll just quickly direct your attention to, I believe it is 303. Let me see. Okay, 4. There's a provision, I'm trying to find the actual citation to it. It's called all other uses. Find it. Okay, it's 303.7. And also, there's a 303.26 similar uses. So those two uses, provisions in there are kind of used as a catch-all, in which that would require someone that comes in to still have to apply, still have to go through a conditional use approval, and they'd have to meet criteria and prove that the use they're proposing, even though it's not specifically defined herein, that use is similar to the nature and the characteristics of the zoning area that they're proposing to go in. and they'd still have to meet the general criteria, the performance standards that we'll address later on. But, so there are two provisions in here, two uses in here that are an attempt to kind of stay ahead of the curve act as a catch-all in the event that sometimes things come in that you haven't thought of or you haven't seen or had no reason yet. All other uses, 303.7. And that's on page 21. And then the similar uses, 303.26 is on page 46. So those deal with the specific uses for conditional use types. Article 4, starting on page 48, is the zoning hearing board. General criteria for evaluation of a zoning hearing board, different exceptions. Again, there are provisions once a zoning ordinance is adopted. Currently, the township doesn't have a zoning hearing board. You don't have a need for a zoning hearing board because there's no zoning officer to make zoning issues. A zoning hearing board, and it's set forth in the ordinance and also further in the MPC, talks about what a zoning hearing board needs to be created and then what jurisdiction the zoning hearing board has. One such example, when we were talking about the permitted uses, conditional uses, special exceptions, all those are permitted by the MPC. The conditional uses stay within the Board of Supervisors, and that was set forth here. If it's a special exception, that would go to the zoning hearing board. That's under their jurisdiction. And it talks about what they would have. Right now, you don't currently have any special exceptions set forth in here, but in the future you may. So that provision's in there, and that's what Article 4 zoning hearing board talks about. And they have the ability to grant waivers, variances. Again, if the provisions, the setback provisions that were on page, I think 7, after the table of uses, if an individual is unable to meet one of those provisions, they can go to the zoning hearing board and ask for a variance, and that's a form of relief that they can be granted. And there's factors set forth, but once again, that's a way that a landowner can get relief in the event they're unable to meet the specific criteria herein. And it would be on a case-by-case basis for the zoning hearing board to consider. And that's kind of what Article 4 goes for. Moving forward on page 49, we move into performance standards and also supplementary regulations. Again, you'll notice that performance standards, that's for anything. It doesn't matter if it's a conditional use, it doesn't matter if it's a permitted use, it doesn't matter if it's a special exception. There are certain performance standards that are located within this document that anyone who's operating has to comply with. If they're not going to be able to comply with it, once again, they're going to have to get relief in some form of a waiver or a variance, whatnot. One of the main items that was discussed at great length between the public and the Planning Commission dealt with noise. Again, the noise levels in here are, for agriculture and village, the proposed use is 60 decibels. For a mixed use, it's for 65. It talks about there's different exceptions, it talks about the different time frames for that. All I can relate, as in previously, these are similar to ones in surrounding townships, and I also believe that one of the Planning Commission members, Jody Noble, who's a township manager, or was a township manager, I believe she still is, indicated that the sound levels are similar throughout the county. That doesn't mean that the township has to accept those. Again, this is a living, breathing document. Whether tonight, a week from now, 2 weeks from now, 2 years from now, anything in here can be revisited. But there are various performance standards and supplementary regulations that are throughout Article 5 here. One of the main ones being the noise operations. Another issue that was brought up in testimony with the court dealt with some of the definitions. I believe one of the definitions in question was the normal agricultural operations. And that's on page 50, subsection F, normal agricultural operations. This specifically talks about the Pennsylvania Right to Farm Act. It's a state statute, and it talks about individuals being exempt from compliance with certain performance standards, certain public nuisance matters. There was a question and there was some discussion about possibly amending that definition from the one that has the Pennsylvania Right to Farm Act in it. Ultimately, the version that was adopted and approved by the planning commission keeps this reference in, but I wanted to point that out to the board. That's something for you to consider, and that was something that was brought up as a concern previously in court testimony. I'll note that for the board. Then we'll move on to supplementary regulations. Again, those are different regulations and different uses that will be found throughout, possibly found throughout. It talks about utilities, talks about outdoor storage, talks about height exceptions, temporary construction trailers. There's various provisions here that individuals would have to, look at and have to comply with or get relief from if they're unable to match that, able to meet that requirement. And buffer yards, fences, walls, all that's in that section. Moving on to section 6, there is signage. This talks about, again, self-explanatory as far as, what signs are applicable, what signs are permittable, what type of application is there. This is one section that you have on here that I would caution the supervisors moving forward. There's always freedom of speech, there's always changing ideas behind language and stuff like that. When you start getting into some type of signage, I would just caution you that the courts have come down and just state you can't really regulate what the signs set. You can't regulate speech, it's gotta be equal across the board. So that's just something to consider, obviously, moving forward. And there's a catch-all provision in here, and the law states that in the event one aspect of this ordinance, since we're on signs, is deemed to be unconstitutional or illegal, that does not repeal the entire ordinance. Again, so, but that's just, again, that's something to keep in mind moving forward. We will move on to the next article. Article 7. Non-conforming uses, structures and lots. Again, I believe the board was here and most of the individuals here at the various planning commission meetings, the different hearings. That was a big concern for a lot of the public, is that what they're doing currently, how is this going to affect what they're doing currently, and is this going to prevent them from continuing on their business as status quo? There's a whole set of case law out there that talks about non-conforming uses, non-conforming structures. It's continually changing, like most of the law. This is a section that talks about what a non-conforming use is, what a non-conforming structure is, and how to handle that moving forward. But the overall idea behind it is that individuals that are unable to meet the provisions that are being proposed here, and ultimately whatever is adopted, if they're not in compliance, aka not conforming, they're deemed non-conforming and they're protected from their current use. Then it gets into whether there's expansion down the road or how far that can go before they would have to come into compliance with this. But that's essentially what this section, this article area deals with, is the non-conforming uses that would be going on right now that would be quote-unquote in violation or unable to meet the standards if there was a new use being proposed after the adoption. The next section talks about rezoning. Individuals under the MPC, specifically section 609, and the township itself can rezone. If you ultimately adopt something, you're going to have a map. There might be a time for a change, or an individual might change their mind and say, I would prefer to go back to being agricultural, or I would like to be mixed use, or whatever it might be. This talks about the procedure to go about doing that. And that's what this section talks about. So again, just based on what this is now, doesn't mean that's what it has to be moving forward. And again, the idea is that there's a procedure there for them to go through and for the board to consider, for the township to consider. It's always updating, always changing. So there's a provision there for rezoning. The next section talks about building permits, occupancy permits, zoning certificates, those different temporary uses. Those specifically the zoning certificate aspect of it. You've never had that, but now there'll be a zoning certificate moving forward. Amendments, the next section. Again, the MPC sets forth how you go about amending, it sets forth how you go about enacting a zoning ordinance. as most of us are aware at this point. It also talks about how you can amend a zoning ordinance moving forward. That's just a reference to that, and the MPC is gonna control on that, and I believe that's Article 10 of the MPC. And then the next section talks about administration and enforcement. The Township Board of Supervisors under this ordinance, Township Supervisors have the duty, and it lists, you know, the different duties. One of the things, like I said, you're gonna have to adopt and appoint members to a zoning hearing board. You know, that's gonna be one of the factors. You're gonna have to name a zoning officer, you know, that's gonna be one of the functions. You're gonna have to, you know, do various things. If you're gonna do some of the things that were listed in here, whether that be an amendment, what it might be, you know, you're gonna have to follow the procedure set forth, and that's kind of what this sets forth in here. And it also talks about what the zoning officer's duties are and how they have to notify individuals and how you go about, you know, enforcing compliance with the zoning ordinance. That's that section. And then finally, the last section deals with definitions. That's Article 12. The definition section, it's 10 pages or so. A lot of you're gonna have the 60 different uses that were described on there. They're gonna be defined. There might be a few other definitions in there, but essentially, that's where an individual is gonna go. You know, if there's a question on what type of use there's gonna be, you know, you're gonna look at that to determine what they fall under. And then you go back to the table of uses and start the process from there. So that's essentially what that provision of the ordinance says. And with that, I will open it up to the supervisors first for questions, comments, whatnot.
Seems like we've been working on zoning for a long time.
I believe you guys, yeah, I think you
If I'm
guys
not,
first started.
running correct, this makes about 2 years this month. We spent a lot of time on working on the ordinance initially as planning committee. And at that point in time, it was turned over to the planning commission, and they worked on it. We voted on this previously, and it's here before us again. The facts don't change. If we want to protect the citizens of the township in some fashion, whether or not this is the exact ordinance or whether this ordinance needs to be amended, I don't think anybody would object to polishing it up and continue to polish it as